5 seconds. Provided further that in respect of facilities for medical treatment and accommodation in hospital, in the case of judges of the High Court other than the Delhi High Court and the Punjab and Haryana High Court, the rules and provisions as applicable to a cabinet minister of the state government in which the principal seat of High Court is situated shall apply. In the case of judges other than the Chief Justice of the Delhi High Court and the Punjab and Haryana High Court, the rules and provisions as applicable to a Union Deputy Minister shall apply. In the case of the Chief Justice of the Delhi High Court and the Punjab and Haryana High Court, the rules and provisions as applicable to a Union Cabinet Minister shall apply. This proviso has come to stay as a part of the rules in the interest and in recognition of the status of the judges who are extended some more and specific allowances by the 1986 amendment in the High Court Judges Conditions of Service Act 1954. Such provisions are Section 21A in respect of facility of a rent-free house to the judges, Section 22B as to the conveyance facility, Section 22C as to the sumptuary allowance, and Section 23D as to the medical facility for retired judges and the family of per and on the same conditions as a retired officer of the Central Civil Service Class 1. In a recent judgment, the Punjab and Haryana High Court has, in the case of M.L. Puri versus Punjab and Haryana High Court Chandigarh, found itself placed to consider a public interest litigation because the government neglected staff cars and left cars which were not roadworthy and dependable to be used by the judges of the court, and also to examine whether the security of the judges was neglected by the government. A bench of the court in its judgment has said, it is quite evident that Section 22B of the Act confers a statutory right on the judge to claim conveyance facility and is entitled to a staff car. Section 22B of the Act casts a statutory obligation on the state to provide staff car to the judges. Implicit in this facility is the requirement that the car allotted for use as such must, both in its class and stated of repair, be such as is fit for use for this purpose, in keeping with the high status of the judge of a high court. In other words, it must always be in a good running condition, not one which on account of normal wear and tear or other defect cases to be a safe or reliable vehicle having the propensity to break down on a journey. Since the case before us has been in respect of the claim of sitting judge who has since retired, falling strictly under Section 23 of the High Court Judges Conditions of Service Act 1954, read with the rules in this behalf, that is Rule 2 along with the proviso introduced by GSR number 1175E dated November 4, 1986, published in Gazette of India Extraordinary 2 Part 2nd Section 3 Subsection dated November 4, 1986. We propose first to deal with this aspect.